And the next case on the docket is Lostaglio versus Lostaglio. Mr. Doran, Mr. Smith. Whenever you're ready.
Good morning, Your Honors. My name is Theodore Doran. I'm with the law firm of, and I'll be reserving 5 minutes. My name is Theodore Doran. I am an attorney with the law firm of Dorn, Sims, Wolf, and Cicchetti. I represent the husband in this matter today, and we brought the initial appeal. There are a number of issues that are before the court and outlined in the briefs, but I want to focus first on a couple of the de novo review considerations. The main one we want you to look at is the length of the marriage in determining durational alimony. And the statute, prior to 2010, courts had great discretion in determining when a marriage began and when it ended. In 2010, of course, the statute became very clear in our view under 6108 subsection 4. It specifically said that the length of the marriage runs from the date of the marriage to the date of filing the dissolution of action. In the durational section of that same 6108 provision, the term length of the marriage is used, and it is used in the context of durational alimony shall not exceed the length of the marriage. In this case, we have a situation where a trial court judge has awarded durational alimony but calculated the length of the marriage from the date of filing the final judgment. And that flies directly in the face of the statute.
11 and a half years, correct?
That's right.
And the trial court ordered durational alimony for 10 years?
10 years, yes ma'am. And that was 2 years and 1 month longer than the length of the marriage.
Was there any order, I know that there was an agreement between the parties that the husband would pay $300 a month.
Yes.
In support for during that separation.
Temporary alimony, yes.
During that separation period.
Yes.
Did the trial court order temporary alimony, or was that just an agreement between the parties?
It was an agreement between the parties that was then consummated by court order. So that the court order then occurred in, I think, September of 2011, and that formed the basis for the temporary alimony. But again, if you look strictly at the literal language of the statute in 2010, I don't think it allows for a court to define a marriage as ending at the time of the final judgment. There are many reasons why that shouldn't occur, and we've laid those out. I don't think you even need to go beyond a literal reading of the language, but if you do, we've set forth plenty of examples where the law has defined the marriage as having ended at the time of the filing of the petition. Equitable distribution statute. The retroactivity of temporary alimony goes to the filing of the petition. All the case law has followed that, and Martinez backs us up on this point. For the court to order it from the final judgment simply just takes it beyond the length of the marriage, which in this case was roughly 11 years. Now, another important and interesting issue that has been raised in this petition, and one that I would really urge you to take a hard look at. The easy thing to do here is to say, well, every other DCA has determined that unless adultery affects the financial status of either of the parties, citing the Noah case out of the Supreme Court, then adultery just doesn't play a role. That is completely inconsistent with your concurring opinion out of the 5th DCA in Baxter. recognizing that it's certainly not binding on you or anyone else, but nonetheless, it was well thought out and it is accurate. The easy thing is to say, let's just go with what everybody else did. The right thing to do is to recognize that marriage as an institution has no credibility if, as under the facts of this case, a spouse can literally lead a double life, unbeknownst to her husband, literally holding herself out to another community, and as living with this significant other for purposes of the of seeking golf memberships and the like, attending all these events. It is unrefuted testimony that she...
Case law seems to indicate that, or does indicate that, I mean, the courts aren't to look at whether one party or the other has had an affair unless there has been some sort of depletion of assets.
No question about it.
Which that wasn't in this particular case. But it seems to me as though the trial court in this case did consider, now to what extent and in what manner is, but there does seem to some indication in the final judgment.
Well, there's no evidence of it other than his statement that he considered it. He did not indicate any specific findings. He did not indicate, as you would under the elements of 6108, with regard to the various elements, how he applied those. The amount of alimony that was awarded to the wife is exactly what the parties had temporarily agreed to, so he didn't diminish it in any way.
How is it exactly what the parties temporarily agreed to when it doesn't account for the tax benefits or the insurance that she was getting and wasn't? Seems like it's significantly less, measurably less, given those two considerations.
Well, let me take one at a time. I don't think it in any way didn't address the tax benefit issue. There was an accountant who testified by us on what the tax implications of that are, and those tax implications apply across the board, and including the temporary alimony.
But I mean, she was not taxed on the temporary support, correct? Because they were filing joint returns. I mean,
no, I think she was. I think she is taxed. I think she will be taxed on the temporary support. I think it's a deduction to the husband.
Those tax years are done, and she did not have to come out of her pocket, out of that support money, to pay income taxes for those years, correct? I mean, that seems clear from the testimony to me.
Well, I don't know about the testimony, but I think the law is pretty clear that it was deductible to the husband and it was taxable to the wife if she didn't claim it.
I mean,
that would be her problem.
They jointly filed taxes, right? So, I mean, the total income was taxed, but she didn't have to take the $5,300 and pay income tax from that.
Well,
correct?
She paid it. She paid it indirectly.
She had that available for her living expenses.
Yeah, she paid it indirectly.
And insurance was paid. She was covered on his insurance during that period, so she didn't have to take money out of that $5,300.
That is true.
So if the $5,300 is what she needed to live, and then why wasn't it error? And I know that these are cross-appeal issues, but I mean, you're saying that she got the amount that she said, and I'm saying that it doesn't look to me like she did.
Well,
you take into account the insurance and the tax.
Well, except that then the court found that she was fully capable of working. So if you take what she was awarded as taxable income of $5,300, which is just short of $64,000 a year, and impute even minimum wage to her, she's over $80,000 a year in income. Now, there was no her position during the litigation was that she was physically unable, medically unable to work, even though she was playing golf 6 days a week. The court clearly made a determination that her position that, and we had to have a doctor come testify to this and everything else, he clearly made the determination that she was, and he stated so, able to work. So even at minimum wage, she's at $80,000 per year. That more than covers any of the considerations that Your Honor is concerned about in terms of a reduction. In fact, I think there was an increase because at that point she was deemed to have that additional income, not on paper, but she was able to work.
You're essentially saying that the cases dealing with adultery's impact on alimony ignore the statute, correct?
Yes. The statute is clear.
But the statute itself says the court may. It's a permissive consideration. Doesn't say must, shall, and certainly doesn't give any kind of formula on how a trial judge should take that into account, should the trial judge wish to. So if it's permissive in the first place, and this judge said, I considered it, how is that, in your sense, violating or not following the statute?
Well, because there is no evidence on the face of the judgment that there was any consideration reflected. And,
But it doesn't say it has to.
well, it doesn't
May,
say,
and the
it
court
does,
said, took testimony, didn't exclude the testimony, heard various witnesses talk about various things, and then,
Sure.
you know, certainly depending on which perspective you're looking at, either got enough or a little less than enough alimony from the one side and way too much, obviously, from the other. But in terms of following the statute, when it's permissive in the first place.
Sure, and, you know, in our first year of law school, we all are, you know, it's beat into us the difference between shall and may, shall requirement, may being discretionary, but can any reasonable person disagree with the idea that under the facts of this case, where she lived a double life, this is not a one-night stand, this is not I happened to meet somebody, this is an unrefuted, unrebutted, uncontroverted statement that she made that the marriage was ended 3 years into the marriage, and that the only reason she was staying was for alimony.
The testimony also with regard to the adultery was that it was a one-night drunken act. And
Well,
that
there's-
this was a marriage of convenience. I mean, that was all in there as well. And in terms of...
There was one witness, yes.
Well, in terms
Not her.
of consideration for that act, I mean, she certainly wasn't provided enough alimony to keep her living in the manner in which she had lived while married, but just to, you know...
Well, actually, I would disagree with
She's not going to be left destitute, but she's certainly not going to be living in the lap of luxury at $5,300 a month either.
Well, I mean, yes, but the standard of living that they were, and the court made this finding essentially, the standard of living that they were maintaining at the time was way beyond what they could afford because of the economic crash. I mean, they paid $1.8 million for a house, and at the time of the dissolution, the husband took on $200,000 in debt in keeping the house. He was the only one with the income that could support the mortgage. There were no other options. I mean, it wasn't even an option for him to sell it because there were no other assets. The only other assets were retirement assets, which got divided between the parties, and actually getting back to the length of the marriage, actually puts the wife in a position of getting $150,000 a year in today's dollars after the age of 59 and a half based on her award. So the durational alimony, again, not only on the basis of a violation of the statute, was an abuse of discretion in the sense that it, since you want to ask a question.
Let me ask you about the house.
Sure.
The husband was awarded the marital home, and there's been an argument with regard to, I mean, the wife is, there's nothing getting her off the mortgage or off the deed, or so she's technically still has half ownership of the home, even though it was awarded to husband. What do you say about what
Well, she
we
doesn't-
do?
Well, she doesn't have any ownership because it was awarded to him, but she is absolutely still on the mortgage, and the law is pretty clear on that. If
Debt, though, right?
She's on the debt, yes. Yes, she's on the debt, there's no question, and the law is pretty clear on that. If there is any way feasible to remove her from that, then the court is required to find that way and accomplish it. But here, it was A, not ever raised at the trial court level, B, even if it had been, and the reason I think it wasn't is because there were no options. Now, there are going to be options going forward. The economy's coming back. I'm sure the house will increase in value, and that is something that they may want to go back and seek redress from at the trial court level if it gets to a point where he could either refinance or sell the home, or it'll just take care of itself. But, I mean, it is what it is, and it's a sign of the times, and that gets back to another important issue for us, which is the court making a determination that all these non-marital asset contributions by the wife, even prior to the marriage and then subsequent, even like 9 or 10 years prior to the dissolution, somehow played a role in a determination of the equitable distribution resulting in unequal.
Was the debt that she's still entitled, she's basically responsible for half the debt on the home, was that calculated into the equitable distribution?
Yes. Yes, it was. Yeah, not the $48,000 home equity line, which is another issue that we've raised, and that needed to be adjusted. It needs to be adjusted in our view in your determination, and hopefully we get a remand on that and other issues. But yes, the $200,000 was calculated into it. But the fact that the wife gave some of her non-marital assets into the marriage, clearly a gift to the husband. It was used to buy properties, including the house that we're referring to, cannot be then used as an argument later to adjust the equitable distribution because, what if the house had increased in value by $1 million? I don't think she would have been suggesting that somehow she wasn't entitled to the benefit of that investment. Unfortunately, it didn't go that direction, and I see I'm close on time unless the court has another question at this point.
Thank you. Do you want to try to save any rebuttal time for your cross-appeal issues?
Yes, I've saved 2 minutes.
2 minutes? Okay, so what'll happen is when you're into that 2 minutes, the yellow light will come on.
Okay.
But you can sit down and save that time, or you can just continue to use it.
The issues seem to be fairly intertwined, so it may just all come out at once. But good morning, may it please the court. My name is Sheila Ennis, and I'm the attorney for Sharon Lostaglio, now known as Sharon Nucci, and she is the Appellate cross appellant in this matter. The consensus of the courts that have considered the issue of what is and what is not a permissible consideration of adultery in fashioning an award of alimony have uniformly stated that the adultery has to actually matter to the case. It has to either have a legal significance, i.e. to defend against a countervailing claim of adultery, or has to have an economic impact on the marital finances. Hurt feelings, moral outrage, these are residue of an era in which fault finding was part of dissolution of marriage, and that has been done away with a long time ago. I think it was 1967 the statute said there shall be no alimony to an adulterous wife. The legislature has removed that ban, and it is a permissive consideration for the court, but again, it has to be taken in the context of Florida's no-fault regime. We are not going to descend into what I think Williamson called the dark days of fault finding. That's just not where our dissolution of marriage is focused, which is on welfare of children and allocating resources in the breakup of the union. Pointing fingers, that's just not where the law is anymore. Our problem in this case is that the alimony awarded was not adequate to meet the wife's demonstrated post-judgment needs, which, as this court's already recognized, included her new liability to pay income tax, her new obligation to buy health care. These are both federal mandates that have penalty provisions if you do not do these things, so they must be considered part of basic needs. And the law has always been historically clear that tax
How do you respond to the argument that that's taken care of by the finding of fact by the trial judge that your client could work? And so even if you attribute a minimum wage to her, that would be sufficient to cover those additional?
Well, he didn't attribute minimum wage to her, and that's the problem. The reduction wasn't quantified. And alimony is a mathematical calculation of need and ability to pay. It can't be an arbitrary number. That is the sine qua non of what is abuse of discretion. You have to put numbers on these things. No income was imputed to the wife. The court expressly stated in the final judgment that there has been no evidence presented for me to say what kind of job she could do.
How can it be an arbitrary figure, though, when that was the figure that was agreed to by the parties prior to the final judgment?
That was a temporary award, and of course, under that temporary award, the husband also provided for the wife to receive an apartment, get herself started, and also they did file joint tax returns by their agreement so that she had no tax liability. Her testimony at trial was that her tax liability was going to be about $600 a month, and we did have the husband's accountant came in and testified to what her tax liability would be. That is a brand new obligation post-judgment that did not exist in the pre-judgment era. The health insurance, the husband was paying $450 a month during the litigation under the standing court order, and post-judgment the wife testified that she had received quotes under Obamacare in the $600 a month range. And of course, health insurance was of great importance to her. While the trial court ultimately found that she was not disabled from working, the court noted, and the husband's own experts and doctors noted, that she had significant medical history with fibromyalgia, carpal tunnel syndrome. She last worked while she was under workers' compensation for carpal tunnel syndrome. She'd had numerous surgeries and had been in 2 car accidents. And her testimony at trial was that she was awaiting yet another surgery. I think it was a lumbar. Don't hold me to it. It may have been something cervical. So she certainly was in need of health insurance, even if it was not a federal mandate, which it is. And the problem, we see that the court did say, I have considered the adultery as requested. And I consider that the wife has breached the marital agreement by committing the adultery. And the problem with that is finding a breach of contract is akin to a finding of fault. So it seems to us from the language of the judgment that the court found fault, and because of that fault gave her less money in alimony. And the problem with that is that there's no way to quantify, even if finding of fault was permissible to do, it wasn't quantified because there wasn't any economic impact. Need and ability to pay is where alimony must remain focused, and that's true from every court that's considered it. Now, the Baxter concurrence...
Well, doesn't need, though, incorporate the ability to work on behalf of the former wife?
It does, and I wouldn't quarrel with it if the court had actually said, well, I impute minimum wage at 40 hours. The problem is that there was no... Although they said, I can find that the wife can work, does that mean 10 hours, 20 hours, 30 hours, 40 hours?
Anybody ask for clarification?
No. Neither side did. And if I could touch on that, we actually had responded to one of their arguments about the equitable distribution under the invited error rule on that, and I just want to make it very clear, it's in our brief, that there was a stipulation. The wife received $15,000 in partial interim distribution during the marriage to pay for her experts. Although we might say that that's invited error, we do think that should be corrected on remand. That's a stipulation from us, and we will not claim technical error. I don't like technical error anyway, and playing gotcha with that. But if the court remands on that issue and remands on the $48,000 home equity line they've claimed, we ask that it be remanded for a full consideration of the entire scheme, and that these liabilities not be distributed to the wife in a vacuum. The alimony and equitable distribution have to be considered together, and if the wife is going to receive additional liabilities in her column, she's going to need something to make up for that. I also want to touch briefly on their argument about when the marriage has ended. It is true that the length of the marriage for purposes of calculating alimony in 6108 is measured from the date of the marriage until the date of filing. That is absolutely correct, because then you run into this twilight zone while we're in litigation, and with the unfunded mandates we have out there, the courts are doing their best to get things through. But the law has always been, and it's in the statute 61052, the marriage is not ended until the judge says it has ended. The court is required to make a finding of fact based on evidence presented that the marriage is irretrievably broken. Until the judge does that, this marriage exists. If either of these parties had died during the litigation, one would have been a widow or a widower. If they had voluntarily dismissed their petitions, the marriage would have continued intact as if it had never been a separation. You cannot be a little bit married in Florida. You are or you are not. You can't be almost divorced. So, and there's some older case law on this. I like the Ryan v. Ryan case very well. It said otherwise the judge becomes reduced to performing ministerial acts. So even to this day, even with a marital settlement agreement where you submit a packet to the court and nobody shows up, you still have to say why it's broken. And the court has to make that finding. So I think that it's an incorrect statement of the law to say that the marriage terminates because somebody filed a piece of paper and said so. They're not the judge. A judge can make a finding someone's insane. As far as the other issue that's near and dear to my heart is the claim of offset of temporary alimony against this post-judgment award of durational, and I have briefed it. But temporary alimony and post-judgment alimony are completely distinct in public policy, purpose, and statutory basis. Temporary alimony is ancient and it is precious, and it still is so in Florida. And as they pointed out in the Belcher case, it is an unbroken line of cases going back to 1845 when Florida first became a state. While you're still married, even if the litigation is ongoing, you are still married, and spouses have a duty to support one another. You can't contract that right away. And when the parties entered into their agreement on temporary support, had they purported to contract to say that this is going to be offset in the end, that would have been unenforceable as against public policy. So you just cannot equate temporary alimony to post-judgment alimony. They're completely different creatures. Dust v. Dust was an older case that I enjoyed as well, and it said that when you're dealing with post-judgment alimony, you're talking about allocating resources between people who have become legal strangers. It's completely different. It's inappropriate to offset, and this court in Nichols v. Nichols back in 1982 found it inappropriate, where a trial court awarded temporary alimony but called, at the statute at that time, allowed a rehabilitative alimony post-judgment. So when the court entered final judgment, says, well, now I'm going to give you rehabilitative alimony, but I've already been paying you rehabilitative alimony for all these years, so you've got a total award of 5 years. This court said, no, that's inappropriate. We do not classify temporary alimony as a form of post-judgment. And it quoted to another case from this court.
Ask about your cross appeal 3, which is the mortgage. Do you agree that you waived that issue by failing to raise it below?
Well, I think that that's the remedy for this court to devise. It was not raised. However, I would point out that the Patel opinion did not come down until 2015, long after the final judgment was entered. And no, it was not raised. And should it have been? Yes, in the sense that every possible issue should be raised. At that time, we just did not have the benefit of this court's opinion, and Patel is silent as to whether it was sought at the trial court level or simply argued on appeal as some kind of error. We don't know the basis for it. We certainly think that we owe it to our client to raise the issue. I will say that it's a matter of equity with a $1.3 million mortgage against someone who's got income by alimony of $63,000 a year. She'll never be able to buy a house again. Another issue I'd like to bring up is the issue of whether the wife was living a double life versus the isolated incident. There was testimony by Mr. Reagan, who supposedly, was the boyfriend, that it only happened one time. And then the wife had testified at a prior evidentiary hearing, and it is in the record of the supplemental volume 2, that it was only one time. So we have their testimony together. I will say the trial court had the benefit of Mr. Reagan's demeanor evidence at trial and did find that, accepted Mr. Reagan's testimony that he had held them out, not the wife. Mr. Reagan had held them out as a couple in order to obtain discounts at the country club or the golf club. So whether the alimony was significant and serial or one time is certainly in dispute, and the court never resolved it either way. And it's our position it's just not relevant because there was no showing of the adultery in this case mattering outside of hurt feelings. And every other DCA has said it doesn't matter unless you can show. And the Williamson case, by the way, wasn't even an adultery case. It was actually a misconduct case. The husband had, both the parties were physically disabled. The husband absconded with their life savings, and the court descended into an analysis of adultery just by way of example and analogy. And that's what started all of this anyway. It was, if misconduct has impacted the marriage, then I don't care what kind of misconduct it is. Adultery is just one thing you can consider, but if there's been a depletion, but you've got to quantify that as well. You've actually covered just about all the issues that I intended to. I would say on the unequal distribution, the court distributed $34,500 in wife's favor in light of not her contribution of nearly $400,000 in premarital assets, but because when she left the marriage at age 52 at trial, she would have no non-marital assets remaining. She gave 100% of what she had. Certainly the husband made significant contributions to this marriage. It has nothing to do with who gave more. It had more to do with who left with more. So whether she should be working or not working, she's 52 years old, unemployed, has not been in the workforce in 14 years, and has significant health issues, and that was a finding of the trial court. She's walking out with nothing. I understand that the husband's argument that he wants to retire at 59 and a half, but a voluntary early retirement is a heavy burden, as the court said in Pym v. Pym. 65 is the presumptive age, and given the husband's date of birth under federal law, his presumptive age of retirement is age 66, which is exactly when the durational alimony ends. And it's a position, the trial court did state that, but for the ability to give this 10-year duration, he would have considered awarding permanent alimony in this unique case, should this court remand, finding that the duration was excessive which we certainly argue against, we would ask the court remand with instructions to award permanent, because if the 10 years is reduced to 7, clearly and convincingly, the wife will have a gap before she reaches retirement age that nothing else can bridge. If you have any questions of me.
Thank you very much.
Thank you very much.
Let me just say at the outset, no disrespect to opposing counsel, but the reference to another evidentiary hearing as something that the wife testified to, we would want to, register our objection to any consideration of anything outside of the trial court record. There is no testimony from the wife, not even one word with regard to the adultery, not one word of refuting or contradicting any of the statements of all of the witnesses that came forward to establish this multi-year, 3-4-year-long relationship that was being conducted in a community where no one knew she was even married. The evidence is clear on that. There is only her boyfriend that said it was a one-time event.
Hard time understanding why you're spending so much time, effort, and energy into explaining the facts relating to that issue when the best that it gets you is a statute that says that it may be considered, and the trial judge said that he considered it.
The reason is because I think it's an abuse of discretion under the circumstances to have not applied it. I don't think marriage, I'm sorry?
The trial judge said he applied?
Well, but there's no evidence of it. None. It certainly didn't explain it, and the amount of alimony be awarded was the same as what they had agreed to before the issue had been resolved. Like I said, it's easy to follow these other districts. It's hard to embrace Baxter, which is your concurring opinion,
Well, I
which
don't think
gives...
we're choosing between the other districts and Baxter. We're choosing between the other districts and the plain language of the statute that says may. And I don't know how you could ever find an abuse of discretion when the statute says may and the trial judge said that he considered it. I mean,
Okay.
Maybe you can tell us this. What cases have said, trial judge, you erred by not considering alimony?
No cases. Yes, there was a case. There's a case, and it's cited in the brief. I'm sorry, I can't think of the name. There is one that did send it back out of the 5th ECA. Is it Eckert, I think? That possibly that send it back in the 5th ECA for consideration of what implications or applications alimony, or what implications to alimony should be considered in light of the...
case where the judge said, I will not consider the adultery.
I don't know that the trial judge said he would not consider it, but the opinion, I don't think the opinion referenced how it came about, but they did send it back for that purpose. It's an interesting issue, no question, but does it mean anything to be married? Does it mean anything? I mean, if you can lead a double life for 3-4 years in another community without your other spouse knowing, your other spouse being completely faithful to you, does it mean anything to be married? Because what Baxter says is it does. And what all these other courts who misinterpret NOAA and say, and apply it to the payee spouse when it's really, NOAA only addresses the payor spouse, it has never been addressed as to whether and what application this has to a payee spouse. So the answer you will give us will tell us all of us who are married, that we can either totally ignore the institution of marriage as we fundamentally know it as a society and without repercussion, and go and be supported for the rest of our life, as she is under this ruling, well into her 60s, based on a 10-year marriage, which she uncontrovertedly said had only existed 3 years, because she was only staying in beyond the 3-year mark for alimony. That's uncontroverted.
Just so we understand your position, it's that it's an abuse of discretion not to leave an adulterous spouse destitute. They need to be
Do
punished.
not leave her destitute? No,
You
I'm
have
not
to leave them
saying.
destitute. You can't provide for their basic needs because
No.
that would be an abuse of discretion. You have to punish them to the full extent of your ability.
No, no.
What
no.
are
Well,
you saying?
Your Honor, please. I mean, it's not an all or nothing thing. There's a lot in between this.
Right.
It's only a 10-year marriage, and nobody's leaving her destitute. She has, at 59 and a half, more income than the average person in the state of Florida, with doing no work whatsoever. And if she works, she's going to have a lot more than that. How many of us make $80,000 a year? So, with regard to her inability to work, her medical conditions,
If there are any other questions, you've exhausted your time.
Oh, I'm sorry.
Judge Edwards?
I thought I had 18 seconds.
So you're down 22 now, so we're now counting down once it hits red. So.
I just wanted to point out that it was pretty clear from all the testimony that the wife had played golf 6 days a week. So, I don't know about this medical issue. Thank you.
I just wanted to clarify the Eckert case because it did come from this court. Eckert was unusual. It was not remanded exclusively for consideration of, and the court said whether the wife's alimony should impact the adultery, the amount of alimony she receives. It was sent back because there was 24 months between the date of trial and entry of the final judgment, and the court was very concerned that the court's memory was not fresh, and the case law is that's just too big of a gap. The record that was before the court just did not have enough findings of need and ability to pay, and that was the reason it was remanded, that length of time, and the court said, and by the way, when you consider need and ability to pay and develop that record, you will also need to consider whether it should affect amount. And that's all that I have. Thank you.
Thank you very much. Thank you very much for your arguments, court's in recess.